Charles Peckham here to talk a little bit about Rule 11 agreements. Very often now that we are using Zoom and video and telephones for resolving cases in mediation, uh, you're not going to be in the same room, you're not going to be in the same place, so signing a settlement agreement can be difficult. And very often mediators, such as myself, we will use emails to record the agreement of the parties, and there may not be a hand signature. So the question really has to do with Rule 11. When is an agreement enforceable, a settlement agreement enforceable pursuant to Rule 11? Well, the rule itself says that unless otherwise provided in these rules, no agreement between attorneys or parties touching any suit pending will be enforced unless it's in writing, signed, and filed with the papers as part of the record, or made in open court and entered a record. So, email agreements. There are a couple of cases I want to talk to you about. One is a case actually out of the federal district court in Dallas that talks about Texas law with respect to Rule 11 agreements. There's no requirement, and this is, by the way, this is Williamson versus the Bank of New York Mellon. And the court said, well, there's no reason to have any kind of slavish adherence to the literal language of Rule 11 and the civil procedure rules. But you go back to the rules of contract interpretation. So a contract principle is that it has to meet the statute of frauds. There's got to be a written memorandum, complete within itself in every material detail, contains all of the essential elements of the agreement so that the contract can be ascertained from the writings without resorting to oral testimony. It doesn't have to be in a single document, it can be a series of emails. But it is the best practice, and we do in mediations here, to make certain that all of the material terms are agreed, they're put in writing, that an email is circulated between the parties or between counsel, and everybody assents, indicates their full agreement to those material terms. So even though it may be reduced later to writing, a more detailed writing, even the emails will allow the settlement to be enforced in court. One other case that I want to bring to your attention is one where I was counsel and we challenged the enforceability of a series of emails being a Rule 11 agreement, and we won at the Court of Appeals. This is Clarent Energy Services versus Leasing Ventures. And the court really hinged in that case and made their decision saying that there was no real meeting of the minds. So again, in mediation, when you go to any mediator, including me, you want to make certain that the material terms are stated within that email and that there's a clear indication of assent, agreement to all of the material terms. I certainly hope that helps you in mediation with me and with other mediators out there. Thanks a lot.